But otherwise, if not, we will work our way through it. And we're also live streaming. So give me just a second to clear everything out on the notification menu here.
And it is the second page of that PDF.
Okay. All right, well, good afternoon, everyone. Let me introduce myself. My name's David Taylor. I'm county judge up in Gilpin County, which is Central City and Blackhawk. It's a little bit west of Golden. It looks like the teams this afternoon are going to be Team 6 and Team 9. Is there a representative from each team who will be able to address the preliminary matters?
Yes, Your Honor.
Yes, Your Honor.
All right, and Mr. Wilcox, I can see you. Who is it from Team 6? I'm sorry.
It's Louis.
All right, great. But just so you're all aware, I have seen Team 9 throughout this whole competition. I'm not a scoring panelist. I'm just here as the presiding judge, so I don't think that's going to be an issue. For our scoring panelists, given the complexity of trying to arrange judges and panelists and everything else in this remote competition, we're not going to have much in the way of conflicts, but do either of you see any names on this list that would make you think it's unfair for you to participate in this round?
I do not.
And Lisa, are you here?
I'm here and I don't have any conflicts.
All right, great. All right, well, just so you're both aware, I really appreciate you both taking the time to be here this afternoon and really throughout this competition. We could not do this without all of you, and this is so valuable for everybody who's participating in it. So I really appreciate that. Let's go ahead and get started with preliminary matters. Team 6, are you prepared to proceed to trial?
Yes, Your Honor.
And Team 9, are you prepared to proceed to trial as well?
We are, Your Honor.
And for Team 6, are there any preliminary matters that you would like to address this afternoon?
Yes, Your Honor. To start off, we would like to ask that the clock be stopped for any internet issues that may occur.
That will certainly be done. I will also let you know if I see that there's any technical issues going on, if we can't hear you, can't see you, or anything else along those lines. And we've had that throughout the competition, as I'm sure both teams are aware by now. So I'll make sure you both get treated fairly. If there's any discrepancies in time that the two timekeepers have, we'll work through those as well. That's one of the more difficult aspects with this remote setting, is for the timekeepers to be keeping track of what they're supposed to be doing. So we will work our way through those issues as they arise. One of the other things that has come up occasionally is that for some of us, when we have a poor internet connection, I've had to ask you to turn your video off. So at least that way we can hear you. It's not the best solution, but it at least lets us proceed forward. So I might be asking some of you to do that, but we will figure that out as we move forward.
We also ask that the stipulated facts and the jury instructions be consecutively read into the record.
Done.
Then we also ask for an opportunity for a redirect after a cross-examination and a recross after a possible redirect.
On the redirect, yes. On the recross, I'll leave that up to the other team. If they want to do that, I'll offer it since you've asked.
Then we also ask for any unfinished time in closing be used for a rebuttal at the end.
That will also be fine.
And that is all our preliminary matters, Your Honor.
All right, thank you. Team 9, are there any preliminary matters that you would like to address?
Yes, Your Honor. We ask that under competition rules 7.4 and 4.7, that a team may use Zoom annotation features to mark exhibits electronically. And once an exhibit is admitted, we ask the court's preference if you would like us to ask permission to mark the exhibit first.
On the use of the Zoom features, that'll be perfectly fine. And then when it comes to marking the exhibits, whatever you think is appropriate to do is fine with me.
And we ask also under Rule 7.4, may we screen share documents and exhibits before they have been admitted with the understanding that they are constructively outside the view of the jury?
That will also be perfectly fine.
There are no further matters from the defense, Your Honor.
Okay, well, let's move to team introductions then. Team 6, would you like to introduce yourselves?
Yes, Your Honor. Good evening, Your Honor, opposing counsel, members of the jury. My name is Louis Stemfer, and joining me at the plaintiff's table is Austin Yee and Cayman Story. It is an honor for us to be here representing the people of Colorado. I will be conducting the cross-examination of Kyle Cusack and the cross-examination of Taylor Perkins. May my co-counsel please present themselves now?
Yeah, go ahead.
Good evening, Your Honor, ladies and gentlemen of the jury, opposing counsel. My name is Austin Yee. I will be doing the direct examination of Alex Fuentes, the cross-examination of Blake Van Owen, and the opening statement for the people of Colorado.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Cayman Story, and today I will be giving the direct examination of Detective Jordan Markowitz, the cross-examination of Avery Becker, and I will also be giving the closing arguments for the people of the state of Colorado. Thank you. Your Honor, may I now ask that our witnesses have permission to introduce themselves?
Of course, go ahead.
My name is Isabella Hensley, and I am Detective Markowitz.
My name is Lauren Manziak, and I am Alex Fuentes.
And team 6, do you have one more witness?
Yes, we do. Sorry.
Okay. We might have run into our first connection issue of this round.
I'm so sorry, Your Honor. It seems that our last witness has been disconnected from the Zoom call, Kyle Cusack. So we're
Okay.
just waiting on them to rejoin.
Why don't we wait on that to work itself out, and then we'll proceed forward. Go. All right. Ms. Renaud, are you the missing witness?
Yes, I'm here. So sorry about that.
Oh, it's perfectly fine. Go ahead.
My name is Angelina Renaud, and I am Kyle Cusack.
All right, and would your timekeeper like to introduce herself as well?
Hi, my name is Haley Thomas, and I am the timekeeper for Team 6.
All right, thank you very much, Team 6. Team 9, would you like to introduce yourselves?
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Freya Naj, and I will be delivering the opening statement for the defense, conducting the cross-examination of Kyle Cusack, and conducting the direct examination of Blake Van Owen.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Daniel Nakayama, and today I'll be conducting the cross-examination of Jordan Markowitz, as well as conducting the direct examination of Taylor Perkins.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Spencer Wilcox, and today I will be conducting the cross-examination of Alex Cifuentes, the direct examination of Avery Becker, as well as delivering the closing arguments on behalf of the defense. At this time, may our witnesses please introduce themselves?
Go ahead.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Henry Falconetti, and today I am Professor Blake Van Owen.
Good afternoon, Your Honor, members of the jury. My name is Anna Sherman, and today I am Taylor Perkins.
Good afternoon, Your Honor, members of the jury. My name is Bella Burgess, and today I am Avery Becker.
Good afternoon, Your Honor, members of the jury. My name is Audra Snyder, and I am the timekeeper for the defense.
All right, thank you, Team 9. Like I said, we will work our way through any connectivity issues as they arise. I'll make sure both teams get treated fairly out of it. The other thing that I'm going to do, and this is to assist our scorekeepers, is at the conclusion of every witness's testimony, I'll ask all of you for your real names just to confirm that we're all on the same page and that we have all of the names correct on the score sheets. But with that being said, is the prosecution ready to give an opening statement?
Yes, Your Honor, the prosecution is ready to open.
All right, you can start when you're ready.
Okay. A man who built a career for himself and found a passion working with youth interested in his same professional career. Little would he know the festering intentions of one of his pupils. On March 6, 2020, a day like no other for Mackenzie Brackman, he would be approached by his pupil, suited in black. Their identity was hidden, just as their intentions were. But soon as they entered Brackman's home unlawfully, an altercation broke out, and just like that, Mackenzie Brackman lost his life. What was the motivation? A student filling in for the sin of pride as they donned ideals of revenge and retaliation. And though not intended, such a role led to the irreversible death of Mackenzie Brackman. To say the least, it was a burglary gone bad. And today, the state of Colorado brings you this case. A beloved lawyer and coach, Mr. Brackman, was struck down by one of his pupils, a pupil motivated by pride, wanting to retaliate, and wanting revenge. This student and their actions brought about by a dangerous pride would lead to an unfortunate altercation and the unfortunate passing of Mackenzie Brackman. The state of Colorado brings you 3 witnesses in this case. The first is Detective Markowitz. With her expertise, she will trace the movements of Becker's cell phone using cell phone tower analysis. And with this knowledge, you will come to the reasonable conclusion regarding the suspect's movements the day of March 6, 2020. Secondly, we will bring you Alex Cifuentes, a peer and one of Avery Becker's close friends. She will lay the groundwork for Becker's intentions the night of March 6. Not only will Becker's motivations be laid flat, but you will gain a great sense of the person Becker is and the person Avery Becker claims to be. Then we will bring you Kyle Cusack. Cusack will lay the foundation to reconstruct the crime scene and bring her conclusions regarding the striking down of Mackenzie Brackman. She will make it evident how the altercation between the suspect and Mackenzie Brackman occurred and how it ended up occurring so that you can come to the most reasonable conclusions. The defense will attempt to lead you to faulty assumptions regarding the condition of Brackman and his home. Their expert will attempt to establish a narrative contradictory to Cusack and Detective Markowitz, but don't let their assumptions raised upon the slightest probabilities sway your opinions. Ladies and gentlemen of the jury, you are all reasonable people with reasonable conclusions. The defense is here to sway those reasonable conclusions. Now, under jury instruction number 8, you'll find the terms for second-degree burglary, i.e. unlawfully breaking into the home of Mackenzie Brackman. And under jury instruction number 7, you will find the terms for murder in the first degree. In this case, the accused would have broken into the home of Mackenzie Brackman unlawfully and intentionally or not committed or attempted to commit murder. The state of Colorado has the burden of proof in today's case. We will provide the necessary evidence to achieve our burden of proof and tip the scales 100 to 0 so that you, honorable members of the jury, will have the facts to find Avery Becker guilty on these charges in accordance to both jury instruction number 7 and 8. Don't let Avery Becker bolster his pride by successfully retaliating without consequence. Come to the only reasonable verdict. Hold Avery Becker accountable for their actions. Hold Avery Becker as guilty.
Sorry, I'm having trouble unmuting here. Thank you, Mr. Yee. Would the defense like to give an opening statement?
Yes, Your Honor.
And you can start when you're ready.
Your Honor, can you see and hear me?
I can, you're good. So go ahead.
A rushed investigation, a rush to judgment. The prosecution just told you that Avery Becker was a pupil filled with pride, which led him to commit an act of revenge. But this is not true, as the defense will demonstrate that this case is the consequence of a rushed investigation and a rush to judgment. Avery Becker did not have a perfect relationship with her mock trial coach, and because of this, the police automatically assumed that she was the main suspect. Due to the police's rushed investigation and rush to judgment, the blame of this case got placed on Miss Becker, the defendant, after a flawed and rushed investigation. A rushed investigation, a rush to judgment. The prosecution has the burden of proof. They must prove to you that Avery Becker broke into her coach's house and killed her coach. They must prove to you each and every element of a second-degree burglary charge and the first-degree murder charge beyond a reasonable doubt. But this will not be possible, as the defense will demonstrate through numerous examples that the prosecution has not met their burden of proof. A rushed investigation, a rushed judgment. The defense does not have a burden of proof, but we will call 3 witnesses who will all show you that Miss Becker had an alibi, that there was a lack of physical evidence, and that there was an uninvestigated alternate suspect. Let's begin with the alibi. Miss Becker will tell you she had an alibi. In fact, Miss Perkins, one of Miss Becker's classmates, will confirm this alibi by telling you that Miss Becker and Miss Perkins were at the mall looking for Miss Becker's phone. Mr. Van Owen, the defense's expert witness, will also tell you that the cell phone records used to place Miss Becker at the crime scene do not work because cell phone records cannot act as a GPS due to their imprecise measurement and large signal diameter. The police also did not investigate any of the individual phones involved in this case, including Miss Perkins' phone and Mr. Cifuentes' phone, even though the prosecution will tell you all of these devices play an important role in today's case. A rushed investigation, a rush to judgment. Let's talk about the prosecution's lack of physical evidence. None of the defendant's DNA was found at the crime scene. In fact, one of the prosecution's own expert witnesses will support this fact. The prosecution will also try to use security camera footage to place Ms. Becker at the crime scene, but as seen in those videos, the only characteristic you can see of the perpetrator is their height and their build. Finally, the police rushed to judgment. They rushed their investigation before even investigating every possible suspect. Mr. Van Owen will show you an alternate suspect, Blair Rollins, who the police disregarded and who had a strong, potent personal motive. A rushed investigation, a rush to judgment. Today, the evidence will show you the police rushed to judgment. The police rushed their investigation, and the prosecution will be unable to meet their burden of proof. That is why, at the end of this trial, we will ask you for a verdict of not guilty. Thank you.
Thank you. The prosecution can call the first witness.
Your Honor, the prosecution calls Detective Jordan Markowitz to the stand.
All right, let me make sure we've got a witness and an attorney for the defense. Do we have our witness for this round?
Yes, I'm the witness. I'm Detective Markowitz.
All right, and do we have an attorney from the defense?
Yes, Your Honor.
All right, you can start when you're ready. Thank you.
Good afternoon, and thank you for being here today. Can you please state your name, spelling the last for the record?
My name is Jordan Markowitz, Markowitz.
And what is it that you do, Detective Markowitz?
I'm a homicide detective with the Denver Police.
How long have you held this position?
I've been a homicide detective for 7 years, but I've been in the police for 13 years.
Do you have any specialized training and expertise?
Yes, of course. I specialize in cell phones. I have a cell phone technology and forensic data recovery certificate from the American Academy of Law Enforcement. I also have a lot of experience regularly accessing cell tower data and downloading the contents of phones.
In how many cases have you used this knowledge?
I've downloaded the contents of hundreds of cell phones, and I've interpreted cell tower data in over 50 cases.
Your Honor, considering her expertise, knowledge, and skill, I now move to admit Detective Jordan Markowitz as an expert in crime scene investigation and phone forensic data recovery.
Is there any objection from the defense?
There's no objection, Your Honor.
All right, the witness is qualified as an expert and you can proceed forward.
Thank you, Your Honor. Detective, what is your relation to this case?
I'm a lead detective, and I also responded to the scene and collected evidence.
When did you first arrive at the scene of the homicide?
I arrived at 14:20, or for those not familiar with military time, 2:20 in the afternoon.
When you entered the house, what did you observe?
I noticed a general state of disarray. There was a knocked over chair in the kitchen, there was a missing knife from the nightstand, and there was a broken plate. But I didn't immediately notice anything stolen, like a missing television. I, of course, obviously noticed the victim in the doorway.
And how exactly did you find the victim?
The victim's body was face down, and they were in a pool of blood. There was a nearby knife, it had a bloody back and shoulder, and there was a visible stab wound.
Did you document your findings?
Yes, I did. I took photos. Unfortunately, some of them were corrupted. I also collected cell phone and tower data from witnesses.
Detective, you mentioned that some of the photographs were corrupted. Did this impact your analysis and conclusion in any way?
No, absolutely not. The photographs were corrupted were mainly of the cast-off pattern that the blood splattered show, and since I have a very good memory, I was able to not only remember that this showed a cast-off pattern, but also how the blood looked, so this did not impede my investigation in any way.
Did you document the way you found the victim?
Yes, I did.
Your Honor, may I now have permission to have a member of my co-counsel display what has been previously marked as Exhibit 2 on the screen?
Go ahead.
Thank you. Detective, do you recognize this image that is in front of you?
Yes, I do.
What is it?
It's an image of the victim, the way that I found them when I went to the scene of the crime.
Is it a fair and accurate representation of the way you found the victim on March 6, 2020?
Yes, it is.
Your Honor, at this time, I would like to offer Exhibit 2 into evidence.
Is there any objection to the admission of Exhibit 2?
There's no objection, Your Honor.
Okay, Exhibit 2 is admitted.
Thank you, Your Honor. Detective, what can you conclude from this photograph?
Ms. Hensley, we can't hear you. I'm sorry. Let's pause the clock.
Can you hear me now?
Yes, we got you now.
Could you please repeat your question?
Yeah, go ahead and restart the clock, repeat your question, and go ahead.
Of course, Detective. What can you conclude from the photograph that is in front of you?
Well, from the photograph, I can conclude that Mr. Brackman was quite literally stabbed in the back. I can also conclude that he was likely trying to leave his residence when he was stabbed, and that he removed the knife himself, as it's not still in the wound and it was not removed from the scene of the crime.
At this time, I would ask that my co-counsel stop sharing their screen. Thank you. Did you observe the upper level of the residence?
Yes, I did.
What did this reveal?
It revealed that nothing had been stolen. There were no missing televisions or laptops throughout the entire residence.
And as a result of this, what is your conclusion of what happened with Mackenzie Brackman's residence on Friday, March 6, 2020?
I believe that there was a break-in, possibly an attempt to vandalize, and that the murder was a result of the intruder being interrupted. I believe that the fight that ensued between Mr. Brackman and the intruder is what led to Mr. Brackman's murder.
After going to and observing the victim's property, how did you continue your investigation?
I downloaded cell phone data, and I also accessed information from Ring cameras as well as the victim's phone.
Did you discover any information about the victim's commitments in personal life?
Yes, I discovered that Mr. Brackman spent a significant amount of his time as a coach for the Colorado High School mock trial team.
And once you discovered that Mr. Brackman was a coach for the Colorado High School mock trial team, how did you proceed?
Well, I went into contact with the school and ended up speaking to a student named Alex Cifuentes.
What information did Ms. Cifuentes reveal?
Cifuentes revealed that a student named Becker had been kicked off of the team and had
hearsay.
Go ahead.
This statement is being offered. This statement is not being offered to. I'm sorry, Your Honor. This statement is being offered to prove that Becker and Cifuentes knew each other through mock trial, and is being offered because Ms. Cifuentes revealed information that is incredibly relevant and important in today's case in establishing a motive for the crime that occurred.
Mr. Nakayama, do you have any further argument?
Your Honor, I just believe the prosecution, is using this as an assertion of a fact.
I think there's a relevant hearsay exception, so the objection's overruled. You can proceed.
Thank you, Your Honor. What information did Ms. Cifuentes reveal?
So Cifuentes revealed that a student named Becker had actually recently been kicked off of the mock trial team. They also revealed that Becker and Brackman got into significant arguments very frequently, and that recently Becker had actually vandalized Mr. Brackman's sports car. They also revealed that Becker had sent text messages that showed a clear intent to vandalize Mr. Brackman's home.
Did you ever contact Avery Becker?
I did, through the school.
Were you able to search Becker's phone?
No, I was not. They claim to have lost their phone, but I was able to get access to their phone records through the company that their service provider.
Is there a document that presents an overview of this information? And
yes, I believe that it's Exhibit 16.
Your Honor, may I have permission to have a member of my co-counsel display what has been previously marked as Exhibit 16 on the screen?
Go ahead.
Detective, do you recognize the document that is in front of you?
Yes, I do.
What is it?
It's a document that shows all of the information I was able to collect from Becker's cell phone.
Is it a fair and accurate representation of the cell detail records from March 6, 2020?
Yes, it is.
Your Honor, at this time, I would like to offer Exhibit 16 into evidence.
Is there any objection to the admission of Exhibit 16?
Yes, Your Honor, hearsay.
Any response?
Your Honor, this document is a regularly conducted business activity of the detective, as on a regular basis in her career, she collects cell phone title data and documents it in findings such as presented here.
Any further argument from the defense?
Your Honor, I would again just argue that the writing on the exhibit made by Detective Markowitz is an assertion of fact made before the trial, so therefore it's still hearsay.
I think this is admissible, so Exhibit 16 is admitted and you can go ahead with your examination.
Thank you, Your Honor. What do these call detail records reveal?
So these call records reveal that Becker's phone took a path from their house to the victim's house and arrived at the estimated time of murder. Becker's phone went from tower 1227-3, which covers Becker's house, to tower 1191-1, which covers Rock Creek Parkway, which is the path one would take to get from Becker's house to Brackman's house, and finally connects to tower 1197-1, which is close to Brackman's house.
And is the path you presume Becker took indicated on this document?
Yes, I believe it's in blue.
Thank you. At this time, I would ask that my co-counsel stop sharing their screen. Thank you. In your expert opinion, what happened on Friday, March 6, 2020?
In my expert opinion, Avery Becker went to Brackman's house with the intent to vandalize the property since they'd been kicked off of the mock trial team. Brackman's ring camera alerted him that someone had entered the house, so he armed himself with a knife that Becker would use to take and kill him in the conflict that followed.
Objection, Your Honor. Opinion on the ultimate issue.
Any response?
Yes, Your Honor. Detective Markowitz has been admitted as an expert in this case, and she's just testifying using her expertise and knowledge in crime scene investigation and cell phone data forensics. She's testifying to what she believes occurred on the day of March 6, 2020.
Is there any further argument from the defense?
Yes, Your Honor. Under Rule 704B, in a criminal case, an expert witness must not state an opinion about whether the defendant did or did not have the mental state to commit the murder.
Response, Your Honor.
Go ahead.
The Detective Markowitz is not commenting on whether the defendant had the mental state to commit the murder. She is simply using the evidence she collected in her investigation to alert the jury of the most likely suspect in today's case.
I think the testimony is acceptable. The objection's overruled.
Thank you, Your Honor. I will proceed. In your expert opinion, Detective, what happened on Friday, March 6, 2020?
In my expert opinion, Avery Becker went to Brackman's house with the intent to vandalize the property in revenge for being kicked off of the mock trial team. And when Brackman's ring camera told him that someone had entered the house, he armed himself with a knife and would get in conflict with Becker. And in the following conflict, Becker would murder Brackman.
In your expert opinion, who do you believe is responsible for Mackenzie Brackman's death?
In my expert opinion, Avery Becker is responsible for Mackenzie Brackman's death. Avery Becker murdered Mackenzie Brackman.
Thank you, Detective.
Objection, Your Honor. Again, opinion on the ultimate issue.
Okay. Any response, Ms. Story?
As I said previously, the detective is not testifying to whether the defendant had the emotional state. She's simply testifying to considering the evidence she has obtained and her expert opinion, who she believes committed the murder of Mackenzie Brackman.
The objection's overruled. I think that's admissible. Did you have any further questions?
No, Your Honor.
All right, is there any cross?
Yes, Your Honor.
Go ahead.
Good afternoon, Detective.
Good afternoon.
Detective, I would first like to talk about the crime or the photographs you took of the blood spatter. You took these photographs, right?
Yes, I documented the evidence at the crime scene.
Right, but you lost these photographs, though, didn't you?
They were not lost. They were corrupted. It's unfortunate, but technological issues can happen sometimes.
But
Like I said,
nonetheless,
it does not impede the investigation.
Detective, you're getting a little bit ahead of me. But nonetheless, you no longer have access to these photographs now, do you?
Ms. Hensley, did you hear that last question?
I did not. Could you please
Okay.
repeat your question?
Can everyone hear me?
Yeah, we've got you.
Okay. Detective, nonetheless, though, you no longer have access to these photographs, do you?
No, these photographs were corrupted. But like I said earlier, this does not impede my investigation because I'm able to remember the photographs as well as what they indicated, which is that a cast-off pattern was made from the blood.
But Detective, I'm not asking about your opinion or what weight the photographs bear in today's case. I'm simply just confirming whether or not the photographs, the photographs you took, you no longer have access to, which you do not, right?
No, they were corrupted.
Thank you, Detective. Now, you interviewed Alex Fuentes, correct?
Yes, I did interview Alex Fuentes.
You obtained his name from a list you got from Colorado High School, correct?
Yes, I did. I communicated with the high school, and I was able to get in contact with Alex Fuentes that way.
Right, and he was the first name on this list.
I do believe he was, yes.
And Detective, when you first started talking with Mr. Fuentes, she told you about a text conversation that she claims had taken place between herself and Avery Becker.
Yes, I did. I do know of this text conversation.
Right, and you asked Mr. Fuentes to bring in her cell phone, correct?
Yes, they did not actually bring in their cell phone, but they were able to send me screenshots afterwards.
Exactly.
That told me of the contact.
Exactly.
These messages.
They never brought in the phone, did they?
No, they did not. But I was able to get screenshots that showed me the content of these messages.
Right, but Detective, because you never physically received Mr. Fuentes' cell phone, you're never able to download the text messages off the phone, were you?
I did not download the text messages. No, I got them through pictures.
Right, and Detective, you also were not able to obtain CDRs for Mr. Fuentes' phone, were you?
No.
And Detective, you obtained CDRs for Avery Becker's phone on March 6th, correct?
Yes, that is correct.
But you did not obtain CDRs for Miss Becker's phone during the time in which Alex Fuentes claimed that Avery Becker had texted her, did you?
Objection, relevance.
Any response?
Yes, Your Honor. This is relevant as I'm simply confirming whether or not Detective Marquis was able to obtain all the necessary information for today's case.
Ms. Story, do you have any further argument?
Yes, Your Honor. I believe opposing counsel is trying to testify whether the detective was able to get screenshots from Ms. Fuentes. Get cell data records from Mr. Fuentes. However, Alex Fuentes is not on trial today, and therefore it is irrelevant.
Okay. I think it's an appropriate question and relevant. So the objection's overruled. You can proceed forward.
Thank you, Your Honor. So, Detective, would you like me to re-ask my previous question?
Yes, could you please repeat your question?
Sure. You never obtained CDRs for Avery Becker's cell phone from the time in which Alex Fuentes claimed to have received text messages from her.
I obtained call detail records from the time of the murder. That's when I felt it was necessary and relevant to know the location of a phone.
So, Detective, that is a yes to my question that you did not obtain CDRs for during the time of the text messages?
I did not obtain CDRs for the time when the text messages were sent.
Thank you, Detective. Now, today you've been tendered as an expert in cell phone technology and forensic data recovery, correct?
Yes, I am an expert.
You've analyzed call detail records in at least 50 cases.
Yes, that's correct.
So, Detective, you would agree with me in saying that a cell phone generally connects to the tower that gives it the best signal, correct?
Cell phones usually connect to the closest tower in most cases. Sometimes if that tower is busy, they would connect to a different one, but generally, and in most cases, they will connect to the closest tower.
And that is the tower that usually gives it the best signal, correct?
Yes, the closest tower.
But Detective, you also just testified that a cell phone may connect to a farther tower that gives it a better signal, correct?
That is possible. It is not usually.
Objection, Your Honor, asked and answered.
Mr. Nakayama, any response?
I don't believe I asked the question, Your Honor, about the cell phone connecting to a farther away tower.
Ms. Story, any further argument?
Opposing counsel has asked this question before when he asked whether the cell phones would connect to the closest tower or a further away tower, and therefore this is just a reiterance of that point.
I think the question is fair, so overruled. You can proceed.
So, Detective, a cell phone does connect to a farther away tower that gives it a better signal?
It is possible, but that is not usually the case. In most circumstances, a cell phone will connect to the closest tower.
Right, but on certain occasions, Detective, a phone will connect to a farther away tower that gives it a stronger signal.
Objection, asked and answered.
All right, I do think you've asked and answered at this point, so sustained.
So, Detective, you testify that Avery Becker's cell phone connected to the tower closest to Mackenzie Brackman's house.
Yes, I did.
And Detective, you plotted this interaction on Exhibit 16?
I'm sorry, my audio is cutting out a little bit. Could you repeat your last question?
Certainly. You plotted that interaction with cell tower 1197-1 on Exhibit 16, right?
Yes, Exhibit 16 shows the 3 towers that Becker's cell phone connected to and the path that the cell phone likely took.
But Detective, I'm simply talking about the interaction with the tower closest to Mackenzie Brackman's house, which you didn't plot, right?
The phone did connect to that tower, and I did plot that connection on the map.
Your Honor, permission to screen share previously admitted Exhibit 16?
Sure, go ahead.
Detective, can you see Exhibit 16?
I can see Exhibit 16.
One moment. So, Detective, this is the cell tower 1197-1, the tower that you believe Avery Becker's cell phone connected to?
I am looking at this. Yes, that is tower 1197-1.
Right. And you believe that Avery Becker's cell phone connected to, let me change that color real quick. You believe that Avery Becker's cell phone, you believe that Avery Becker's cell phone connected to Mackenzie Brackman's house, correct?
I connect to the house?
To the tower, I meant.
Yes, this is the tower that Avery Becker's cell phone connected to.
But if that cell tower were busy, Avery Becker's phone could have been over here and still connected to that tower, right?
Yes, it is possible that the phone connects to a different tower if it's busy, but it's unlikely. In most cases, the phone will connect to the closest tower.
But Detective, I'm not asking about the likelihood. I'm simply asking that it can happen, which it can, right?
It is possible.
Is it yes to my question, Detective?
Yes, it is possible for a phone to connect to a farther tower.
Thank you. No further questions.
Is there any redirect for this witness?
Yes, Your Honor. Detective, do you believe that having just the screenshots of those text messages impaired your investigation in any way?
Absolutely not. What was important was the content of these messages, and the screenshots showed the content perfectly.
And was there any other way Alex Cifuentes furthered your investigation?
Yes, they also talked about the many conflicts and the vandalization of a car that happened, and when Becker vandalized Brackman's car. They
Objection,
told
Your
me
Honor.
about
Outside the scope of the cross.
Response, Your Honor.
Go ahead.
Opposing counsel asked Detective Markowitz to testify about her investigation of Alex Fuentes and their conversation they had in that interrogation, and this is just pertaining to that information.
Your Honor, may I respond?
Go ahead.
I was simply ascertaining information about whether or not Detective Markowitz received text messages. I was not ascertaining information about the content of those text messages. So therefore, I believe the questions about vandalization on redirect are outside the scope of the cross.
Okay. I think it's acceptable under these circumstances. Overruled.
How did Alex Fuentes further your investigation?
Alex Fuentes told me about the relationship between Becker and Brackman and provided me with the huge break in my case to discover the major conflicts between Becker and Brackman, as well as showing me that Becker had already broken the law when they were angry with Brackman.
And Detective, considering that the phone connected to the 3 towers along the route from Becker's to Brackman's, do you believe that it is a coincidence?
No, I do not. In my expert opinion, even though it's possible that the phone connects to a farther tower, the phone connecting to 3 towers tracing along the exact route one would take from Becker's house to the victim's house is no coincidence and shows that Becker's phone was in fact traveling along this route to Brackman's house.
In your expert opinion, who do you believe is responsible for Mackenzie Brackman's death?
In my expert opinion,
Objection, Your Honor,
Avery
outside the
Becker
scope
is
of the
responsible.
cross.
I'm sorry, there was an objection and a little bit of an overlap there. Ms. Story, did you hear the objection?
I did, Your Honor.
Okay. Any response?
Yes, I do not believe that this is outside the scope of the cross, considering that every single question in opposing counsel's cross-examination pertains to whether the fact Avery Becker did or did not commit this murder.
Any further argument?
Your Honor, I was not ascertaining information about whether or not Ms. Becker committed the crime or not. I was simply just talking about the connection of her cell phone to the various cell towers.
I think it's acceptable. You can ask the question.
Detective, in your expert opinion, who do you believe is responsible for Mackenzie Brackman's death?
In my expert opinion, I believe that Avery Becker is responsible for Mackenzie Brackman's death.
Thank you. No further questions.
Mr. Nakayama, do you have any recross?
No recross, Your Honor.
All right, let me just verify everyone's name. For the prosecution attorney, I have Cayman Story and Isabella Hensley as the witness, and the defense attorney is Daniel Nakayama. Is all of that correct?
Yes, Your Honor.
All right, thank you. And the prosecution can call the next witness.
The prosecution calls Alex Fuentes to the stand.
All right, do we have the witness?
Yes, Your Honor.
All right, and do we have an attorney for the defense team?
Yes, Your Honor.
All right, Mr. Yee, you can go ahead when you're ready.
All right, thank you. Could you please state your name and spell your last for the record?
Alex Fuentes, Sifuentes.
Good evening, Ms. Fuentes. What is your relation or your involvement in this case?
I was on the same mock trial team as Avery and head coach Brackman, and I firsthand saw the conflict that went on between them and how rocky their relationship was. I didn't picture it would end up like this, but now I want to honor Mr. Brackman and bring justice to Avery Becker.
I'm sorry to hear that, Ms. Fuentes. If it's not too hard, could you describe your relationship with Mr. Brackman a bit more?
Yeah, that's the least I could do, but he was an amazing coach and an even better lawyer. You could just tell by his beautiful car that he had, but he always wanted us to do as best as we could and be prepared for whatever would come. He was an amazing person and an even better coach, like I said before.
And Ms. Fuentes, do you know the defendant in the courtroom today?
Yes, I do. Avery Becker.
And could you go a bit more in detail with your relationship with Avery Becker?
Yeah, Avery and I were close friends. We were on the same mock trial team and we worked together a lot. I mean, they were a good person, and I definitely thought that we were close and that they trusted me, because otherwise they wouldn't have reached out to me all this much. But yeah, we were definitely close.
And did Miss Becker and you typically interact outside of mock trial?
Avery and I usually would just go to the Fry Shack after competitions and events for mock trial. There we would just talk and enjoy mock trial and all that. We also texted a few times after the incident with the Sharpie, and the night before Avery was planning to trash Mr. Brackman's house.
And Ms. Fuentes, what do you mean by the incident with the Sharpie?
There was this one night after, I think it was a competition, that Avery actually picked up a permanent marker and wrote on Mr. Brackman's car, "Worst Attorney
Objection,
Award."
Your Honor. Improper character evidence. Move to strike.
Mr. Yee, any response?
Your Honor, the incident that the witness is describing is an incident that would describe prior motive for the defendant and would go to show further develop their motive in this case and the trial at hand.
May I respond?
Yeah, go ahead.
Your Honor, I believe that the risk of this testimony being admitted runs the risk too greatly for propensity, to the point where it would be confusing and misleading to the jury, which would disqualify it under Rule 403.
I think this is admissible, so the objection's overruled. Mr. Yee, you can continue with your questioning.
All right. Would you like me to repeat the question, Ms. Fuentes?
I think I can pick up where I was at.
All right.
He wrote with a Sharpie on Coach Brackman's car, Worst Attorney Award. And Mr. Brackman didn't take it too well, and Avery was kicked off the team after that.
And could you elaborate on what happened with Ms. Fuentes being kicked off the team?
Avery was, they texted me after being kicked off and asked me to talk to Coach Brackman to try and get them back on. And I did. I mean, if they didn't trust me enough to reach out and ask something like that big favor, then I don't know.
Ms. Manziak, if you're able to hear me, I think we've lost your connection. Let's go ahead and pause the clocks.
All right. Your Honor, quick question about the time. In the chat, I see that one of the timekeepers is counting up. I just want to make sure that that is how it's working out. Just that way I don't get confused.
How much total time remains for the prosecution? All right, so one timer has 9:38 remaining.
Ms. Fuentes, are you able to hear us now?
Yeah. Yes.
All right.
Okay. Does the other timer have a time remaining for the prosecution?
I was counting up from how long your direct has been so far, and it's been almost 4 minutes.
Okay,
So,
I just wanted to make sure since I saw 3 minutes and got concerned.
Okay.
Yes.
All right. It sounds like we're all on the same page here. So, Ms. Manziak, you can hear us now?
Yes, I can. Sorry
Okay.
about that.
No apologies necessary. Like I said, we'd work through it. Let's restart the clocks, and Mr. Yee, you can continue.
All right, so Ms. Fuentes, can you elaborate a bit more on Miss Becker being kicked off the team?
So Coach Brackman kicked them off the team after that incident with the Sharpie that I explained before. Later on, they texted me and just asked me to talk to Coach Brackman to get back on the team. But long story short, Mr. Brackman was not backing down on his decision.
And did anything happen between the two of you after this?
I mean, there was one night at the Fry Shack after a competition that we saw Avery and Taylor together, and as a reward for talking to Coach Brackman for Avery, they let me play on their phone.
All right, and did anything transpire after this interaction?
After this interaction, I mean, we just played games on their phone, and then I, like a couple days later, heard that Coach Brackman had died.
And Your Honor, may co-counsel share our screen with what has been previously marked as Exhibit 14?
That's fine.
All right, Ms. Fuentes, do you recognize the image provided?
Yes, I do.
And is it a fair and accurate representation?
Yes, they are. Yes.
And to your knowledge, has it been tampered with in any manner?
No.
Your Honor, or Ms. Fuentes, what is the image provided to you about?
These are the texts that Avery sent to me before all of this happened about breaking into Mr. Brackman's
Objection,
house.
facts not in evidence.
Mr. Yee, any response?
Question to respond. I am just laying the proper foundation that Ms. Fuentes knows of the image and what it is entailing so that I may admit it into evidence.
May I respond?
Yeah, go ahead.
Your Honor, I believe the witness was about to talk about the content of the text messages, which is not allowed, as these text messages have not been admitted into evidence yet.
I got the impression it was, I felt like it was more background to the text messages. So, Mr. Yee, you can proceed forward.
All right. Thank you, Your Honor. Your Honor, motion to move Exhibit 14 into evidence.
Is there any objection to Exhibit 14?
Yes, Your Honor, hearsay.
Motion to respond, Your Honor.
Go ahead.
Under Rule 803, this is an admission by a party opponent, and therefore it is not hearsay. And if it were, it is not offered for the truth of the matter asserted either. And also under Rule 803, it's an excited utterance and in present sense impression as well.
Mr. Wilcox, do you have any further argument?
First of all, to the 801D2 objection, the defense contends that these are not actually statements from Ms. Becker, instead that these were actually forged by Ms. Cifuentes. As to the present sense impression, Your Honor, we believe that these weren't made under severe emotional duress, as these were also not made by Avery Becker.
I think these are admissible. So the exhibit's admitted, and Mr. Yee, you can go ahead.
Thank you, Your Honor. And Ms. Fuentes, what is Exhibit 14 detailing?
Exhibit 14 is just showing Avery's text to me just before the break-in into Mr. Brackman's house, talking about it.
And did you take any action the night of March 6, 2020?
I texted Avery and I tried to tell them that they shouldn't do it, but I guess they didn't listen.
And is there anyone else in the court you know today?
Yes, Taylor Perkins.
Do you have any relationship with Taylor Perkins?
Taylor Perkins and I, we were acquaintances. I definitely knew them, and we were on the same mock trial team. They graduated last year, but I know that they were super close with Avery.
And did you and Ms. Perkins typically interact outside of mock trial?
Not a whole lot, but I know there was that one night I saw Avery and Taylor at the Fry Shack. We talked a bit and played some games on Avery's phone.
And could you describe your relationship with Blair Rollins in any manner?
I knew of Blair Rollins. I just heard about the case from the school and what happened to their parents, but I didn't really get to know them too well.
Thank you, Ms. Fuentes. I have no further questions at this time.
Is there any cross?
Yes, Your Honor. Ms. Fuentes, let's just get right into it. You say that you were friends with Avery Becker, correct?
Yeah, I'd say we were pretty close.
And you also said earlier on direct examination that you really only spend time with Avery in mock trial activities, correct?
Yes, I mean, it's always good to have a friend in your outside school activities or in school activities.
Right, you claim that you were really good friends.
I mean, we talked quite a bit, so I would say we're close, yes.
Really, you were actually rivals, weren't you?
I wouldn't use the term rivals. I mean, we were.
I'm sorry, Ms. Fuentes, I think we lost you there.
Yeah, Ms. Mantek, if you could turn your screen off, I think that might help out with at least the audio connection. So I'm sorry to have to do that to you, but it might help make it a little bit more stable. And can you hear me?
Yes, I'm so sorry.
No, don't apologize. Pause the clocks for just a second. And like I said, if you could turn your screen off, that might help. If you can't figure out how to do it, we'll work through it. But let's see what happens now.
Okay, sounds good.
All right, Mr. Wilcox, go ahead.
You claim you weren't rivals. Let's dig more into that. At mock trials, you always came to practice prepared.
Yeah, I spent hours working on everything and I took pride in that.
Exactly, you took pride in that. Well, in contrast, Avery was never prepared.
I mean, they had different work ethics than me, so whatever worked for them was okay, I guess, yeah.
You thought Avery was constantly late, though.
Yeah, that was a little bit annoying just because it put our team in jeopardy, but like I said, it wasn't a huge deal.
But you didn't like that, Ms. Fuentes, did you?
I thought it was inconsiderate to the team.
So that's a yes to my question, you didn't like that?
It wasn't my favorite thing, no.
And she could always just make stuff up on the fly in competition, correct?
Yeah, she was really good at improvising.
Without any preparation.
Not that I knew of, no.
And this irked you, didn't it?
It did. I mean, I prepared and I wanted to do well for our team. It also put our team in jeopardy at times when we didn't know what was going on.
So that's a yes, it irked you.
Objection, Your Honor, asked and answered. The witness has already testified to the question.
Mr. Wilcox, any response?
Your Honor, I'm just clarifying the witness's answer.
Mr. Yee, do you have any further argument?
I believe the witness already said yes, but it didn't really have a huge impression on them, as it was just in the sake of preserving the image of the team and helping the team run more functionally.
I think the question is acceptable on cross. Overruled. Mr. Wilcox, you can go ahead.
Thank you, Your Honor.
You think that a lot of people on the team just couldn't stand her?
I think they had some trouble with her at times, yes.
And you felt that she left the team in a constant state of anxiety?
It was a little nerve-wracking not knowing what was going to happen next.
And you didn't like how she treated her teammates?
I would say that's fair. They always came unprepared and it threw us off.
In fact, you thought that she didn't have any real talent.
She had her own talent. I mean, I'm definitely...
Mr. Fuentes, I'm using your own words here. You thought that she didn't have any real talent.
At times, yes.
That she was just coasting along on her good looks.
I mean, that did help her out in the end.
So that's a yes?
I guess, yeah.
So you confronted Coach Brackman about her, correct?
I did, yes.
In fact, you did this multiple times.
I was trying to help out Avery at one point, yes.
Are you sure it wasn't because you thought that she was dragging the team down?
I don't think so. I was just talking to get her back on the team.
Once again, Mr. Fuentes, I'm using your own words here. You thought that she was dragging the team down, didn't you?
I mean, like I said
Objection, Your
before,
Honor. The question is argumentative. Opposing counsel is asking for the witness to agree with his testimony.
Mr. Wilcox, any response?
Your Honor, I believe these are valid cross-examination questions to be asking.
Mr. Yee, is there any further argument you'd like to make?
I stand by my objection.
Okay, I think it's an acceptable line of questioning for cross. Overruled. Go ahead.
I'll re-ask the question, Mr. Fuentes. You thought that she was dragging the team down, didn't you?
she came unprepared and put our team in jeopardy. So for competitions, yes, I did believe that.
And then when you confronted her, you hated how she always played the victim.
Yes, I wasn't a big fan of that.
And you thought her getting awards in competition was a slap in the face, didn't you?
Only because I spent so much time preparing for my own role that it was a little frustrating, and for the team to put in jeopardy, like I've been saying before.
Exactly. Because of all that, you thought it was a slap in the face.
At times, yes.
And then she eventually got kicked off the mock trial team, correct?
Yes, she did.
And because of this, you got a larger role.
I did, but that was never an intended thing.
But with this role, you thought that you could get the Best Attorney Award.
I had that in mind and I wanted to pursue it, yes.
And not Avery.
Yes, because Avery was out of the picture at this point.
Okay, Mr. Fuentes, let's move on to the investigation. You got a call from Detective Markowitz, correct?
I did.
Asking you to come down to the police station.
Yes.
And you told Detective Markowitz about the text you supposedly received from Avery.
Yes, I did.
But at this interview, you didn't bring your phone.
Yeah, I was in a huge rush and I left my phone charging upstairs because it had such a bad battery. And like I said, I was in a huge rush, so I just had to go out the door and I completely forgot about it.
Precisely. You didn't bring it because you forgot it.
Yes, I forgot about it.
So instead, you sent Detective Markowitz screenshots.
Yes, I did.
And then this phone, you sold it months ago, right?
Yes, I did.
So Detective Markowitz never got to see the physical phone, correct?
But she did see the screenshots.
I'm not asking about the screenshots. I'm just asking, she never got to see the physical phone. And the answer to that question is yes, correct?
It's no, she never got to.
No further questions.
Is there any redirect?
Brief redirect, Your Honor, but before I start, can I ask for a time check?
How much time does the prosecution have remaining?
All right.
All right, 7 minutes. There you go.
All right, thank you, Your Honor. To reiterate, what was your relationship with Miss Becker like outside of mock trial?
Miss Becker and I were close friends. Like I said before, on the team, we may not have worked the best together because of our different work ethics, but teammates are like that. And out of mock trial, they were a great person.
And could you elaborate on why you wanted to help Miss Becker get back on the team?
I wanted to help Miss Becker or Avery get back on the team because they were a good attorney and I know they could be used well in our competitions. And because they trusted me enough to ask me to talk to Coach Brackman.
And to reiterate, what happened when the police brought you in for questioning?
When I was asked to go in, I once again forgot my phone at home and I just went to the station and answered some questions and later sent screenshots.
And what happened with the text messages?
I'm sorry, could you...
what happened with the text messages when the police asked about them?
I said I had forgotten my phone at home and that I'd send screenshots, which I did.
All right. Thank you, Mr. Fuentes. No further questions.
Mr. Wilcox, do you have any recross?
None necessary, Your Honor.
All right, thank you, everyone. Ms. Manziak, thank you for working through those connection issues. Let me just verify everyone's names to make sure we've got it right. I've got Austin Yee as attorney for the prosecution, Lauren Manziak as witness, and Spencer Wilcox as defense attorney, correct?
Yes, Your Honor.
Okay. All right, I don't hear anybody speaking up telling me I'm wrong, so you can call your third witness.
The prosecution would like to ask for Kyle Cusack to the stand.
Okay, is our witness online? There you are. Okay, and do we have an attorney for the defense as well?
Yes, Your Honor.
All right, go ahead.
Good afternoon, Ms. Cusack. Please state your name and spell the last for the record.
Absolute. My name is Kyle Kuzak, last name spelled K-U-Z-A-K.
And how are you involved in this case today?
I was put on as a crime scene reconstruction investigator for this scene.
And what do you do for a living, Ms. Cusack?
I work for the Colorado Bureau of Crime Scene Reconstruction Investigation, and I've been on this board for about 19 years.
And do you have any qualifications for this position?
Yes, I have my many years of experience and also the schooling that I went to get this.
Your Honor, I would like to admit Ms. Kyle Cusack as an expert in crime scene investigation and reconstruction.
Is there any objection to that designation?
No objection, Your Honor.
Okay, the witness is so designated, and Mr. Stemfer, you can continue.
May you please explain how you conduct your reconstructions, Ms. Cusack?
Absolutely. I use my highly effective and efficient method that's a 5-step process that allows me to synthesize all the information and evidence I would find in a case in order to form concrete conclusions about them.
And how did you use this in this case that we have today?
I simply started by collecting the evidence at the start of where I could find some. So in this case, it was with the ring videos.
And what did you find in those videos?
In the videos, I knew that the ring system would first notify brackman that there was an intruder approaching, which would allow him to prepare himself with self-defense and also to confront the intruder. And I also saw with the intruder themselves that they were prepared.
And what happened following this?
What happened following the ring videos is that the intruder, since they were prepared with their all black and also knowledge of the premises and the habits of brackman, due to the fact that they were maneuvering themselves in a proper manner, allowed me to tell that the intruder knew brackman to some extent, or most likely knew brackman's habitudes, and therefore was someone that knew brackman.
And what did you find once you entered the crime scene?
Once I entered the crime scene, I saw that there was most likely a struggle that happened due to various broken plates, misplaced items, and things such as scuff marks within the kitchen.
And do you usually take any documentation of evidence?
Yes, we took photos of such things that I mentioned earlier.
And you mentioned these photos. May I please, Your Honor, may I please show the witness what was previously marked with Exhibit 8, 9, and 18?
Sure, go ahead.
Do you recognize these?
Yes, these are the photos that we took for the crime scene in the kitchen.
And what are they?
They are the photos that I mentioned earlier that we normally take as evidence within a crime scene.
And are they a fair and accurate representation of the photos you took?
Yes, it's very fair, accurate representations of the photos that we take in our normal business practice.
And have they been tampered with?
No.
Your Honor, I'd like to move Exhibit 8, 9, and 18 into evidence.
Is there any objection to Exhibits 8, 9, and 18?
No objection, Your Honor.
All right, those are admitted.
Ms. Cusack, what do these photos show to you?
These photos showed to me initially with the broken plate and also the scuff mark that there was a struggle that occurred at the kitchen due to the fact that brackman was alerted that the intruder was entering through the kitchen. This therefore entails that there was a confrontation between the two. Now, considering the fact that brackman was stabbed with a knife and there's a missing knife block that we see in Exhibit 8, there's a missing knife in the knife block that we see in Exhibit 8. I know that as brackman had taken the knife as a means of self-defense, which was then later used as his murder weapon.
And what happened in the struggle you previously mentioned?
In the struggle, Brackman had held the knife as a self-defense method and then had the confrontation with the intruder. From there was a bit of struggle as they were walking through the kitchen, which led to things such as a scuff mark and broken plate. After that, it was then that the intruder had taken the knife and stabbed Brackman in the back, bear hug style.
And what followed this stabbing?
After the stabbing, the intruder had left through the front door and Brackman had walked towards the front door as well, pulled out the knife, which led to him bleeding out to death.
And in your expert opinion, Ms. Cusack, what is your final opinion from this investigation?
In my final opinion, the intruder was most likely someone that Brackman knew due to their knowledge of the premises and preparation, and the attack was an intended burglary that led to a struggle and confrontation, which led to Brackman's death. It was a burglary gone wrong.
Thank you, Ms. Cusack. No further questions, Your Honor.
Is there any cross for this witness?
Yes, Your Honor.
Okay, go ahead.
Your Honor, can you see and hear me?
Yes.
Good afternoon, Ms. Cusack. Let's start by talking about the evidence you found at the crime scene. The police found a bloody knife at the crime scene, correct?
Yes.
And none of the defendant's DNA was found on that bloody knife, correct?
The intruder was shown wearing gloves in the ring videos, so no DNA should have been found.
But again, that was a yes. That was a
yes,
no.
there was
to my
no
question.
DNA. The intruder was prepared, so there was no DNA.
Next, Ms. Cusack, I'd like to talk about your investigation. Isn't it correct that your conclusion about this case was that this case is a planned burglary gone bad?
Yes.
And are you aware of the ring videos?
Yes, I did mention them in my testimony earlier as well.
And Exhibit 12, and the ring videos are fair and accurate copies?
Yes.
Your Honor, permission to enter Exhibit 12?
What is Exhibit 12?
Your Honor, may I lay more foundation?
Go ahead.
Ms. Cusack, what are the ring videos?
They are videos taken by the security system around the house that depict the intruder approaching the house near the kitchen.
And those are Exhibits 10, 12, and 13, correct?
Yes.
Your Honor, permission to enter I would like to enter Exhibit 12 into evidence.
Objection, Your Honor, lack of foundation.
Any response?
Your Honor, I have just laid the foundation that these are fair and accurate copies of what Ms. Cusack recovered from the crime scene, and that she is aware of them, and I also laid the foundation as to what they are.
Mr. Stem, for any further arguments?
Yes, Your Honor. Opposing counsel never confirmed these videos with the witness currently today, so there's no way that she is aware of what's going to be admitted into evidence.
I think the witness has confirmed that Exhibit 12 is what she recovered, so that can be admitted. Go ahead.
Co-counsel, could you please screen share Exhibit 12? Thank you, co-counsel. You may stop screen sharing. Ms. Cusack, I'd like to be crystal clear about what you know about the intruder. The person in the ring videos is wearing gloves, correct?
Yes.
They are wearing a mask?
Uh-huh.
And they are wearing a big hoodie, correct?
Yes, they're very prepared for some sort of crime.
So the only characteristic you can see of the perpetrator is their height and build, correct?
I can actually tell from the way that they're dressed, certain intentions and motives behind the intruder, and then pairing that with evidence from the rest of the crime scene, I can put together who the intruder might be. But from that alone, yes, I can't make a case.
Ms. Cusack, you're getting ahead of me. The only characteristic from those videos they can see of the perpetrator is their height and build, correct?
From the one piece of evidence in my entire case, yes, I can only make one assumption about them.
So isn't it correct that you can't tell me what color skin the intruder has?
I can't tell them from one piece of evidence. No.
You can't tell me what color eyes the intruder has?
No, from just a video, no.
You can't even tell me what gender the intruder is.
Not from one video, no.
Okay, Miss Kuzak, I would like to move on to your investigation. Your conclusion about this case was that it was a planned burglary gone wrong, correct?
Objection, Your Honor. Asked and answered.
Any response?
Your Honor, I'm just clarifying the witness's answer again.
Mr. Stemfer, any further argument?
Yes, Your Honor. Opposing counsel previously asked the exact same question.
Okay, I think it's acceptable under these circumstances. Overruled.
Miss Kuzak, are you aware of Exhibit 5?
Yes.
Or do you know what is Exhibit 5?
Off the top of my head, I might need to see it. Sorry.
Co-counsel, could you please screen share Exhibit 5? Miss Kuzak, can you tell me what this image is?
It's the image of the bloody knife or murder weapon used.
And is this a fair and accurate copy of what you saw at the crime scene?
Yes.
Your Honor, I would like now to enter Exhibit 5 into evidence.
Is there any objection to Exhibit 5?
No, Your Honor.
Okay, Exhibit 5 is admitted.
Ms. Kuzak, as you know, this is Exhibit 5.
Yes.
Exhibit 5 was the murder weapon in this case, correct?
Yes.
And isn't it correct that the brand of this knife was a Chicago cutlery knife?
Yes.
And co-counsel, you may stop screen sharing. Aren't you aware that there is a knife block in Mr. Brackman's kitchen?
Yes, in which there was a missing knife.
And aren't you also aware that the rest of the knives in Mr. Brackman's knife block were from a J. Henkel's knife set?
Yes, I had actually considered this in my analysis and found that it was actually quite common for people to have mismatching items.
Timekeepers are saying you've run out of time.
Okay, thank you, Your Honor.
All right, Mr. Stemfer, do you have any redirect?
May I please have a quick time check before?
We've got 34 seconds from one of the timekeepers. Does the other timekeeper have a time available? All right, that's quite the difference. I'll split the difference and say 1 minute. That's about right in the middle of that.
Thank you, Your Honor. Ms. Cusack, do you specifically need DNA evidence for your reconstructions?
No, in fact, I don't need to have concrete 100% evidence if I have a pool of evidence that can prove the point without it. So with the collection of evidence that I got today, it was more than sufficient for me to determine it was someone that knew Brackman and it was a burglary gone wrong.
Thank you, Ms. Cusack. Your Honor, no further questions.
All right, I believe that was your last witness.
Yes, Your Honor, the prosecution rests at this time.
All right, let me just confirm all of your names. I've got Louis Stemfer as attorney for the prosecution, Angelina Renault as witness, and Freya Naj as attorney for the defense. All of that correct?
Yes, Your Honor.
Okay, I see you all nodding your heads, so thank you, and the defense can call their first witness.
Your Honor, the defense calls Professor Blake Mano into the stand.
All right, do we have the defense witness?
Yes, Your Honor.
And do we have the prosecution attorney? Do we have an attorney for the prosecution?
Yes, Your Honor.
All right, you can go ahead and start.
Could you please introduce yourself?
My name is Blake Van Owen.
And what is your current occupation, Mr. Van Owen?
I am a private investigator and a professor at CU Denver.
Before that, did you have any other occupations?
Yeah, I served in the Aurora Police Department for a brief few months.
Before your professional career, did you attend college?
Yes, I went to Ashford University, and there I got my master's degree in criminal justice.
Let's move on. What is your role in this case?
Well, you should know I was hired by the defense to review this police investigation.
Have you ever testified as an expert in court before?
Oh yeah, I know my way around a courtroom.
And specifically, in what areas have you testified?
Three big ones would be cell tower analysis, crime scene reconstruction, and forensic evidence techniques.
You just mentioned you've testified as an expert in cell tower analysis. How many times have you testified as an expert in this area?
Cell tower analysis, 5 times.
And as part of your expert testimony, do you review cell tower documents and cell tower records?
Well, yeah, there's not much to talk about otherwise, is there?
You also mentioned you've testified as an expert in crime scene reconstruction. How many times have you testified as an expert in that field?
Crime scene reconstruction, I've talked about that 8 times, I think.
And I would now like to tender Blake Van Owen, an expert in crime scene reconstruction, cell tower analysis, and general police investigation.
Is there any objection to that designation?
No objections to those tenders, Your Honor.
All right. The witness is designated as the requested expert. You can go ahead.
Mr. Van Owen, as part of your investigation, what materials did you review in today's case?
I reviewed the police reports, the crime scene reconstruction by Kyle Kuzak, as well as the cell tower documents prepared by Detective Markowitz.
Did you reach any conclusions through your investigation?
Yes, I concluded that the police have completely rushed to judgment and completely rushed this investigation, totally helter-skelter.
Could you explain a bit more?
Well, I'd say there are 3 big areas that I'm particularly concerned with. The cell tower records, the police investigation itself, as well as a lack of investigation into an alternate suspect.
Let's begin by talking about your first area of concern, the cell phone records. What conclusions did you reach about this particular area?
With cell phone records, there's just no way to prove Avery Becker's location just with those documents.
How did you reach this particular conclusion?
Well, I actually looked through the phone records of Avery Becker and used my academic intuition.
How did you use the cell phone records?
Well, when you look through the cell tower records, you can actually determine that the defendant could have been at a maximum of 6 miles from the victim's house. You can also, if you think about it, the defendant's phone being at a location doesn't mean the defendant was at that location. Despite what you might believe about teenagers, they're not always glued to their phones.
More specifically, why are these cell phone records not enough to justify Miss Becker's location?
Cell tower data can't be used as a GPS because a cell phone actually doesn't necessarily connect to the nearest tower, especially in urban areas.
Let's talk about the police's investigation. Did you reach any conclusions about this area of concern?
Yes, like I said, the police's investigation was extremely rushed. Evidence of varying levels of cruciality was simply omitted. Detective Markowitz came to an easy conclusion, but not the correct one.
Why do you think the police's investigation was rushed?
I think there are kind of 2 big reasons why I think this.
What is the first reason?
Well, several photos of blood spatters that were around the home were actually corrupted and lost in this investigation. I think that demonstrates quite a lack of competence on the police's behalf. I mean, listen, I take a lot of photos of blood spatters, okay? I've got an entire hard drive just of blood spatters. I have never lost one.
And what is the second reason why you believe the police's investigation was rushed?
The police failed to obtain Alex Cifuentes' phone. I think that's quite a crucial piece of evidence.
Do you know why the police didn't obtain Alex Cifuentes' phone?
I don't know. All they did was just accept some easily manipulated screenshots from Cifuentes directly.
Do you know if the police have any regulations or procedures around these particular actions?
They do. The police department has specific cell phone processing technology just for situations like this that they simply didn't use.
Finally, Mr. Van Owen, I'd like to talk about your third area of concern, the police's investigation of other suspects. Did you reach any conclusions about this area?
Yes, like I said, the police completely failed to investigate quite a potent, crucial, or alternate suspect.
Were you able to find this other suspect?
Yes, I believe the suspect to be former CHS student Blair Rollins.
What were you able to find out about this other suspect, Blair Rollins?
I looked through some CHS yearbooks and I found out that Blair Rollins about matches the height and build of the intruder in the Ring doorbell videos. As well as through some internet research, I found out that he's probably not in Colorado anymore.
Did you find anything else through your research?
Well, I found out that Blair's father, Jonathan Rollins, was actually convicted with the victim as his defense lawyer. And in that trial, Jonathan said something like he'll get Brackman back if it's the last thing he does, something along those lines.
Objection, Your Honor. Hearsay.
Any response?
Your Honor, the witness is referring to an exhibit, specifically an audio clip that has been stipulated as authentic.
Your Honor, motion to respond.
Yeah, go ahead.
If the witness is referring to an exhibit, the exhibit has not yet been admitted into evidence, so I would like the witness to not speak about the contents of the exhibit until it is.
I think that's a fair request. So the objection's sustained, but I think you understand what your option is. Go ahead.
Thank you, Your Honor.
Mr. Van Owen, did you find the specific evidence that supports the motive for this alternate suspect?
Yes, I did.
And what is that?
Well, this is an audio clip from Jonathan Rollins' trial. I think it's exhibit 22 or something.
And would you recognize this audio clip that was played today?
Oh yeah, it was very memorable.
I'd like to enter exhibit 22 into evidence. And Your Honor, it has been stipulated by the parties that this audio clip is authentic.
All right. Mr. Yee, do you have any objections to entering this into evidence?
The only objection would be hearsay, as I previously noted.
All right. Ms. Nash, do you have any response to that objection?
Your Honor, this exhibit goes to support the motive for this alternate suspect.
Mr. Yee, do you? I'm sorry, I didn't mean to walk on you.
No, I'm finished, Your Honor.
Oh, okay. All right. Mr. Yee, any further arguments?
No further argument. I just stand by my objection of hearsay.
Your Honor, another response.
Go ahead, Ms. Nash.
This exhibit also goes to support the statement of a plan. It is an excited utterance.
Okay. Mr. Yee, do you want to respond to that?
No response to that, Your Honor.
All right. I think that's admissible under an exception to the hearsay rule. So the exhibit is admitted and you can proceed. Go ahead.
Your Honor, permission to play exhibit 22?
Yes, go ahead.
Co-counsel, could you please screen share and play exhibit 22? Co-counsel, we were not able to hear, or I was not able to hear that audio clip. Could you please screen share and play it again?
Yes, let me know if you can hear it now.
I'll get you back, Brackman. It's the last thing I do.
Thank you, co-counsel. You may stop screen sharing. Mr. Van Owen, do you know if Blair Rollins was present at his father's trial?
I do. Blair Rollins actually testified on his father's behalf at one point, so he was clearly there when Jonathan was convicted.
And do you know if Blair Rollins was present at school the day of the murder?
Blair Rollins was absent the day of the murder.
No further questions.
Mr. Yee, do you have any cross?
Yes, Your Honor.
Okay, go ahead.
Right. Mr. Van Owen, you were an officer for the Aurora Police Department, yes?
For a brief period, yes.
And during your time there, you injured a young woman of color?
Objection, Your Honor.
Go ahead.
Improper character evidence and relevance.
Your Honor, motion to respond.
Go ahead.
I feel that this testimony is very important into developing the character of Professor Van Owen and goes to show his credibility in the court today.
Ms. Nosh, do you have any further argument you'd like to make?
Your Honor, this is improper character evidence because opposing counsel is trying to use this bad act to show as example of Mr. Van Owen's behavior.
Motion to respond, Your Honor.
Sure.
I'm not using this action to describe Professor Van Owen's repeat actions, as this case is not about Professor Van Owen, but rather just to show his credibility in the court.
Okay. I do think that goes to the witness's credibility, so overruled, you can proceed.
Thank you, Your Honor. Again, during your time, you injured a young woman of color, correct?
It's one of my biggest regrets, yes.
And in the following case, you reached a settlement?
We did, yes.
And following the settlement, you left the police department?
I just didn't feel comfortable being part of that institution anymore.
And moving on, you are currently a teacher at CU Denver, correct?
Yes, I am.
You haven't had a previous occupation or education in forensic evidence techniques, correct?
Well, I don't need one.
And you have grown to dislike police procedure since your incident?
Again, like I said, I just don't think that this is our most well-designed institution, so no.
And thank you. You also solely testify as a defense expert witness now, correct?
If I don't, nobody else will.
And part of this has to come from your no longer trusting the law enforcement personnel since your incident?
Well, I guess you could say that's part of it. I also just simply enjoy being in a courtroom. Testifying is a lot of fun.
Thank you, Professor Van Owen. And moving on, you've been previously involved with the expert witnesses of this case, yes?
Yes, I have.
Now, you are particularly fond of Kyle Cusack and his work, yes?
I can't say that I am, but I don't let it affect my judgment in this case.
But you're also not fond of Detective Markowitz and her work, yeah?
Again, can't say that I am, but I'm trying. I have tried to be as impartial as possible.
Thank you, Professor Van Owen. Now, moving on. You claim that the hold of the knife in this reconstructed situation is improper, yes?
It is.
Let me ask you, in a life or death altercation, one wouldn't stop to think about how they hold a knife, yes?
Well, that depends on the life or death situation, doesn't it? I mean, sometimes when you're in a very stressful situation, you can feel like time is going in slow motion, and you can determine.
Thank you, Professor Van Owen. Let me just rephrase the question a little bit. If someone was vying for their life, they wouldn't think about how they grab a knife to defend themselves, correct?
Well, they could. Like I said, time slows down with the adrenaline, but in most cases, sure, yes.
And in this case, the way that a person holds the knife could take any form as they're fighting for their life, correct?
I'm not sure I understand the question, counsel.
In this case, the hold on the knife could take any form since two individuals are fighting for their lives, correct?
yes, I suppose any way of holding this knife in this altercation or possible altercation would be possible.
Thank you, Professor Van Owen. Now moving on, the cell tower records indicated the phone connected to a cell tower near Avery Becker's home the day of March 6th, correct?
Yeah, they do.
And then the cell tower records also indicated that later in the day, it moved into territory and connected to a cell tower near Mr. Brackman's home, correct?
Well, it did connect to a cell tower near Mr. Brackman's home. However, I wouldn't
Thank you,
say that that
Professor Van
indicates
Owen. You've answered my
that it connected
questions.
to the that it was in the area. You know, in urban areas especially, phones can connect to towers that are actually quite far away.
And so there is clear indication of movement between the two cell phone towers from Avery Becker's home to Mackenzie Brackman's home, correct?
Well, I wouldn't call it a clear indication. It can be interpreted that way, but it's not.
Professor Van Owen, the cell phone did connect to a tower in Avery Becker's home territory and then move into Mr. Brackman's home's territory, correct?
Again, it did connect to a tower near Avery's home and then a tower near Mr. Brackman's home. However, that does not necessarily indicate it was moving between those two areas.
And Mr. Van Owen, you've also stated that the movement of the phone is similar to the route that Mr. or Avery Becker would have to take to get to Mr. Brackman's home, correct?
I have, yeah.
Thank you. And now moving on, Professor Van Owen, you've stated that the photos depicting the victim's blood droplets would have no weight in this case, correct?
Well, they didn't affect this, no.
And it wouldn't attribute to any theories of who the killer may be?
No, but I think that indicates quite a lack of competence on the police's behalf.
And Professor Van Owen, we aren't arguing whether or not Mackenzie Brackman was murdered, yes?
Well, we all know he died, yeah.
So, Mr. Van Owen, it would be wasted time for government officials to analyze and bring those blood droplets into this case, correct?
Well, that depends. I suppose yes, but again,
Thank you, Professor
it
Van Owen.
demonstrates a lack of competence.
Now, moving on, you have no conclusive evidence to bring you to your conclusions that Alex Cifuentes and Blair Rowlands were in contact, correct?
I can't say that I do.
And you also have no conclusive evidence that the text messages brought to the court by Alex Cifuentes were forged?
I don't think that you guys have evidence that proves that they aren't.
And also, the phone was believed to be lost at the mall, correct? Avery Becker's phone, to clarify?
Yes.
And that is why Taylor Perkins and Avery Becker were searching for the phone at the mall?
That's what they said. They were looking for the phone at the mall.
So the likelihood that your theory of Blair Rowlands encountering Avery Becker's phone at the Fry Shack is minuscule, correct?
Well, I wouldn't call it minuscule. I'd say that it's actually something that we need to consider.
But the phone was believed to be lost at the mall, yes?
Yep.
And your theory is that the phone was found by Blair Rowlands at the Fry Shack, yes?
Yes.
Thank you, Professor Van Owen. No further questions.
Is there any redirect for this witness?
Yes, brief redirect. Excuse me, I'm just prepping. Mr. Van Owen, do you let your opinions sway your work?
No, I don't. I'm always as impartial as I can possibly be.
And in your investigations, did you use all the pertinent information you needed?
Yes, I covered all the relevant evidence and I based my conclusions off of that.
And why are the cell phone towers not enough to justify Avery's location?
Well, as I discussed, a phone doesn't necessarily connect to the nearest tower, especially in urban locations. So if you're trying to track somebody's movement using a phone, that's just not a viable method of determining movement.
Thank you. No further questions.
Sorry, I was having trouble unmuting here. Mr. Yee, do you have any recross for this witness?
No recross necessary, Your Honor.
Okay, thank you all. Let me just confirm your names. For the prosecution, we have Freya Naj as the attorney, Henry Falconetti as the witness, and then for the defense, or excuse me, I had that backwards. For the defense, those were the attorneys and the witness, and then for the prosecution, Austin Yee is the attorney. Okay, you can go ahead and call your next witness.
The defense calls Taylor Perkins to the stand.
Do we have our witness?
Yes, Your Honor.
And do we have opposing counsel?
Yes, Your Honor.
All right, you can go ahead and start.
Good afternoon. Could you please introduce yourself to the jury?
Hi, my name is Taylor Perkins.
Ms. Perkins, do you go to school?
Yes, I do. I'm currently a freshman at CU Boulder.
Ms. Perkins, do you know Avery Becker?
Yes, of course I do. We were teammates on our school's mock trial team.
Let me interrupt for a second. Mr. Nakayama, I think your connection has got some bandwidth trouble. Could you turn your camera off just to see if that makes a difference?
Can you hear me now, Your Honor?
Yeah, a little bit better. Let's see how it goes. I'm sorry to have to ask you to do that. Go ahead.
Ms. Perkins, do you need me to re-ask my previous question?
Yes, please.
Do you know Avery Becker?
Yes, of course I do. We were teammates on our school's mock trial team.
Were you and Avery friends?
Friends? We were besties. I mean, we literally finish each other's sentences. We're so close. So yeah, we're definitely friends.
And Ms. Perkins, did you know Mackenzie Brackman?
Yes, of course I did. Coach Brackman was our mock trial coach.
Ms. Perkins, why are you testifying here today?
Unfortunately, Coach Brackman was murdered.
Ms. Perkins, did Avery Becker kill Mackenzie Brackman?
I know for a fact
In Your Honor,
that Avery.
I'm sorry, I heard objection. I couldn't hear any of the rest.
Objection, Your Honor, to speculation.
Mr. Nakayama, any response?
Your Honor, I don't believe this is speculation, as Ms. Perkins testified to why she is testifying here in court today. So therefore, Your Honor, I don't believe it is speculation.
Your Honor, response.
Go ahead.
This question asks for an answer that would be required from an expert opinion. And currently, Ms. Perkins is not entered as an expert.
Your Honor, may I respond?
Sure.
If I make an offer of proof, Ms. Perkins is going to testify that she was with Avery Becker the entire day on March 6th.
Okay.
May I respond, Your Honor?
Go ahead.
Again, this goes completely out of the scope of the knowledge of the current witness, as they may testify to that specific point, but currently they will be speculating against the current trial, which goes up to debate for if Avery Becker murdered Mr. Brockman, and this is completely out of the scope of the witness.
Given that offer of proof, I think the testimony is appropriate. The objection's overruled, and Mr. Nakayama, you can proceed.
Thank you, Your Honor. Ms. Perkins, would you like me to re-ask my previous question?
Yes, please.
Did Avery Becker kill Mackenzie Brackman?
I know for a fact that Avery did not kill Coach Brackman.
How do you know this, Ms. Perkins?
Well, you see, I was with Avery the whole day of March 6th, and seeing as we were nowhere near Coach Brackman's house, I just don't see how it's possible. I mean, you can't be in two places at once.
Thank you, Ms. Perkins. So you mentioned earlier that you and Avery Becker competed in mock trial. Could you describe your experience in the program?
I mean, I didn't have a huge liking for it. It was a nice way to spend time with Avery and all, but it wasn't to my liking.
Ms. Perkins, from your perspective, or what did you observe about Avery Becker's time in mock trial?
Oh, Avery was great. I mean, she could literally do the bare minimum, and somehow she still came out on top. It did drive our coach nuts, though.
Miss Perkins, were you able to observe the relationship between, or the interactions between Avery Becker and Mackenzie Brackman?
I'd say so, yeah.
Did you observe any sort of conflicts between the two?
Well, there is this one conflict that comes to mind. I believe it was before regionals. Avery came to practice completely unprepared. I mean, it was the worst I've ever seen her. And as you can imagine, the coach wasn't exactly thrilled about it. And, one thing led to another, and Avery was demoted to the B team.
Miss Perkins, was this demotion permanent?
No, it wasn't. So I decided to step down from the team. It was the right thing to do. And mock trial it wasn't the same without Avery.
Thank you, Miss Perkins. Now, I'd now like to direct your attention to March 5th of 2020. What do you recall about afternoon of March 5th?
Well, Avery came over to my house and, we just did the usual. We hung out, we played video games, and then eventually we got hungry. So we decided to go get something to eat.
Miss Perkins, where did you guys go?
Oh, we went to the Fry Shack, which is a place we go to hang out.
And Miss Perkins, is the Fry Shack a public place?
I believe it is, yes.
Were there other patrons there?
Yeah.
Miss Perkins, did you recognize any of the patrons?
Yeah. Unfortunately, we bumped into the mock trial team while we were there.
Miss Perkins, what was so unfortunate about this interaction with the mock trial team?
Well, we came over to them and talked to them for a while. It was the polite thing to do. And Avery got upset over something, and she just stormed off. And I believe she even left her phone behind, which is it's quite unusual for Avery.
Miss Perkins, why was this unusual?
Well, you see, Avery is really attached to her phone. It's like a third kidney or something. But she was pretty upset, so I'm not even surprised that she left her phone.
Miss Perkins, how long were the two of you at the Fry Shack?
Not very long. We then went to the mall, and that was pretty much it for the day.
Thank you, Miss Perkins. Now, do you recall the following day, March 6th of 2020?
Oh yeah, that was a pretty eventful day.
Miss Perkins, what do you remember about March 6th?
Well, I recall texting Avery about a ride to school, which is something we do pretty often, but for some reason she wasn't responding to my texts.
Were you ever able to get into contact with Avery on that day?
Yeah, Avery eventually came to pick me up. And, I asked her why she wasn't responding to her texts. And that's when we realized that she lost her phone the day before.
Miss Perkins, did you guys ever go and look for the phone?
Yeah, so we decided to ditch school that day because, we were done with finals and the classes were kind of boring and we had nothing else to do. So we decided to spend the day looking for her phone.
Miss Perkins, where did the two of you look?
So we retraced our steps. So we went to the mall and then we went to the Fry Shack. And let me tell you, that place is like a mock trial magnet.
Miss Perkins, how did the two of you look for the lost phone?
So we tried calling and texting the phone several times.
And did you guys find the phone based off of this?
No.
Miss Perkins, were you guys ever near Mackenzie Brackman's house on this day?
No, absolutely not. We were nowhere near Coach Brackman's house that day.
Thank you. No further questions.
Is there any cross?
Yes, Your Honor.
Go ahead.
Ms. Perkins, you previously mentioned that you were both on the mock trial team, correct?
For 4 years.
And you found that she didn't always try the hardest on the mock trial team. Isn't this correct?
She didn't have to. She was that talented.
But she was later demoted to the B team, correct?
Yes, after a conflict with the coach, unfortunately, Avery was demoted to the B team.
Thank you. And this upset her, didn't it?
Well, yeah, of course. She loved mock trial and she was so good at it. So, I mean, how would you feel?
You could even say that this hurt her pride.
I mean, yeah. She was so good at it, and the coach just demoted her to the B team. We were all shocked. She was our best attorney.
Thank you. And you felt that Avery deserved your position on the A team more than you did, correct?
I wouldn't say so. I mean, she liked mock trial better than me, and I quit because I just didn't see the point of staying without her. So that is why I quit.
But you know that if you quit from the A team, that she would have your position. Isn't that correct?
It's something that was just an addition to all the other benefits of quitting mock trial. I wasn't having fun and I wasn't enjoying it. So that is why I quit. I did not quit just so Avery could get back onto the A team.
Just to clarify, that's a yes to my previous question.
Yeah, probably.
Thank you. Moving on. After one specific practice, in an act of retaliation, Becker went out and wrote worst attorney award on Brockman's beloved.
Objection, Your Honor. Lack of foundation as to how the witness would know this.
Mr. Nakayama, you're breaking up a little bit. I heard lack of foundation.
Yes, Your Honor.
Okay. Any response?
Yes, Your Honor. You see, currently, Miss Perkins just said that she was on the mock trial team and that she had a connection with Miss Becker. And as we know, that means that she definitely knew all the events that occurred around mock trial while she was still part of the team.
May I respond, Your Honor?
Go ahead.
This event took place after Miss Perkins had left the team, so therefore she would have no knowledge of this.
Response, Your Honor.
Sure.
As Miss Perkins and Miss Becker were close friends, usually close friends do tell each other everything. And Miss Perkins did previously state that she was aware of many of the events that occurred in Miss Becker's life.
Why don't you lay a little bit of foundation for that? Ask some of those very questions.
Thank you, Your Honor. Miss Perkins, after some of the regional competition, you were in contact with Miss Becker, correct?
Well, of course, she's my best friend.
And are you aware of one particular practice that occurred where there was some conflict between the coach and Miss Becker?
I wasn't there to personally witness it, but I do recall Avery telling me about it.
And in your recollection from what Avery told you, didn't she mention any acts that she did afterwards?
Yes, Avery came to me and told me about what she did, and she was so sorry, and she regretted what she did so much. She even tried to apologize to the coach many times, but he just wasn't accepting her apologies.
And this act, just to clarify, was when Miss Becker went out in an act of retaliation and wrote worst attorney award on Brockman's beloved vehicle.
It was a mistake that Avery still regrets. She will probably regret it for the rest of her life. And she, as I said, she apologized to Coach Brackman many times.
But she still did this act, correct?
Yes, she did.
So it was with little surprise that she would have gotten kicked off the team?
Well, yeah, I mean, I guess.
Moving forward to the day of the crime, you and Becker weren't at school, isn't this correct?
We did decide to ditch school that day because, as I said, we had no more finals to take and the classes were pretty dry. So we didn't see a point.
And at that specific time when the murder would have occurred, it was only you and Avery that were together, to your knowledge, correct?
I mean, we were in public places, and if you bothered to pull up the security footage, I guarantee you that you would see both me and Avery.
Thank you for mentioning you were in a public place. In that public place, currently today in this courtroom, there is nobody from any of those places that can testify that you two were together. Isn't this correct?
I guess, but hey, don't blame Avery for your incompetence.
But that answer was a yes, correct?
I guess there is no one that can verify our alibi in court, but as I said, we were in public places.
Thank you. Now, moving on, you later in your affidavit claimed that Blair Rollins would be a likely suspect. Isn't this correct?
Yeah, I mean, that guy is shady.
But you did also state that you would have never guessed that he could do this until it was brought up to your attention. Isn't this correct?
I mean, as soon as I heard about Coach Brackman's murder, Blair Rollins came to mind.
Just to iterate, you did state previously that until it was brought up to your attention that...
Objection. Asked and answered.
Response, Your Honor.
Go ahead.
The witness is saying something completely different than what was previously written. So I'd just like to reiterate what was previously stated by making sure that she's aware of what she stated.
May I respond, Your Honor?
Sure.
I believe Ms. Perkins provided an adequate answer to opposing counsel's question.
I think the questioning is acceptable under these circumstances. Overruled.
Thank you, Your Honor. So just to repeat my question, Ms. Perkins, you did state that until someone brought up Blair Rollins would have done this crime, possibly, you would have never guessed that.
I mean, I don't think so, but when I thought of it, it made sense. I mean, as I said, that guy is just shady.
And going back to how you said that you thought of it, didn't you say that you used reasoning from a Netflix TV show to show that this could have been possible?
I guess.
Thank you, Ms. Perkins. No further questions, Your Honor.
Is there any redirect?
Briefly, Your Honor. And just to check, can you hear me all right with my camera on?
You're still coming across a little garbled.
Is this a little bit better?
It is. It is.
May I proceed, Your Honor?
Oh, you can. Go ahead.
Ms. Perkins, why did you quit mock trial?
I quit mock trial for many reasons. It just, it wasn't fun without Avery, and I just wasn't enjoying it. So that is the main reason why I quit.
Thank you, Ms. Perkins. Now, directing attention to March 6th of 2020, why were you and Avery not at school?
As I said, we ditched classes that day to look for Avery's lost phone.
And Ms. Perkins, where did you guys look?
We retraced our steps, so we went to the mall and then to the fry shack.
And Ms. Perkins, were these places public places?
Yes, they were.
Thank you. No further questions.
Is there any recross?
No recross at this moment, Your Honor.
Okay, let me just confirm all of your names. For the defense, we've got Daniel Nakayama as attorney and Anna Sherman as witness. And for the prosecution, Louis Stempfer as attorneys. All of that correct?
That seems to be correct.
All right. Okay, thank you all, and you can call the third defense witness.
The defense calls Avery Becker to the stand.
Do we have our witness?
Yes, Your Honor.
All right, and do we have the prosecution attorney?
Yes, Your Honor.
Okay, you can go ahead and start.
Could you please introduce yourself?
Hi, my name is Avery Becker. I was a senior at CHS when Coach died.
Okay, Avery, let's just get this out of the way now. Did you kill your mock trial coach, Mackenzie Brackman?
No, I would never do something like that.
Okay, so let's talk about the day that Coach Brackman was killed. He was killed on March 6, 2020. Where were you that day?
I was at the mall. I was looking for my phone with my best friend, Taylor.
Did you ever end up finding it?
No, we tried calling it, but it kept going straight to voicemail. So we figured it was either dead or stolen.
Okay, Avery, we'll circle back to that phone a little later. For now, let's talk about your relationship with Mr. Brackman. How did you meet him?
I was on the mock trial team. He was our coach.
And how did you feel about him?
Mr. Brackman, the two of us, we might not have seen eye to eye on how to do mock trial, but he was still an incredible coach. He's the reason that our team did so well. He's the reason we got where we did.
Now, it's been brought up previously, an incident at the practice after the regional tournament. What happened at that practice?
Well, I was doing some run-throughs on my material, and Mr. Brackman came in and he started criticizing me. And normally I'm open to constructive criticism, but it felt different.
Specifically, how did you feel?
I was angry. I was really upset, just because he was just telling me about everything I was doing was wrong.
So what did you do?
I stormed out and I went and I grabbed, I thought I had grabbed a dry erase marker, but I ended up getting a Sharpie, and I went out to the parking lot and I vandalized his car.
Why did you think that you were using a dry erase marker?
I had been using one earlier to write on the board during practice, and I thought I had picked it up again, but I guess I didn't.
What did you do when you realized that it was, in fact, a permanent marker?
I ended up going home and I cried for a bit. My mom ended up helping me calm down, and she told me to go in and apologize.
Did you?
I tried to. The next day I went into his office and I tried talking to him, but his secretary said he didn't want to see me, which I don't blame him.
Did you try anything after visiting his office?
Yeah, I did. I tried texting him, just saying how sorry I was and what I would do to make it up to him, but he never responded.
What did you say you would do to make up for it?
I promised that I would try to I would personally scrub off all of the marker. And I even offered to get a summer job so that I could pay to get it repainted.
Did he ever respond?
No, I never got the chance to tell him how sorry I was.
Okay, Avery, let's go back to the phone from before. You said that it went missing at the Fry Shack on March 5th. Could you go more in detail about that night?
Yeah, of course. I was at the Fry Shack with Taylor, and there were a couple other people from the team there as well.
Did you recognize anyone specifically?
Yeah, Alex Fuentes was there.
And as you've heard in court today, Avery, Ms. Fuentes claims that you texted her that night. Did you send those texts previously shown as Exhibit 14?
No, Avery, Alex is the last person I would text for help.
Why is that?
Well, she likes to say that we have a sort of friendly rivalry, but there was nothing friendly about it.
Why was there a rivalry?
Well, we were always competing for the top spot in the team. We were always trying to best each other. But for Alex, I think it was a bit more personal. And now, with me off the team, she finally has a chance to get that best attorney award she always wanted.
So how did you feel about Miss Fuentes?
Well, first, she was there the night my phone got stolen, and now she's claiming that I texted her when I know I didn't. So, yeah, I guess you could say I'm not the biggest fan of her.
No, Avery, just to be as clear as you possibly can. Did you break into Mr. Brackman's house?
No, of course not.
And did you kill Mr. Brackman?
Objection asked and answered.
Any response?
Your Honor, I believe the question about the burglary has not been asked yet.
Response, Your Honor.
Go ahead.
I was not objecting to the question about the burglary. I was objecting about the question to whether or not Ms. Becker killed Mr. Brackman, which was addressed earlier in opposing counsel's direct examination.
I think it's acceptable. The objection's overruled. You can proceed.
Avery, did you kill Mr. Brackman?
No, I could never hurt another person.
No further questions, Your Honor.
Is there any cross?
Yes, Your Honor. Ms. Becker, you have previously testified that your relationship with the victim was somewhat hostile.
I mean, it was tense. I wouldn't say hostile.
But you would agree that you disliked one another, correct?
No, he was still a great coach and I still looked up to him, but just because the two of us didn't see eye to eye on how to do mock trial doesn't mean we
But you
disliked.
did have a tense relationship, correct?
Yeah, it could get tense at times.
Actually, you would go as far as to say that you hated each other?
I mean, I wouldn't say we hated each other. I looked up to him a lot.
But it is your belief that Mr. Brackman hated you, correct?
Sure felt like that sometimes.
And this animosity was present throughout your 4 years on the Colorado High School mock trial team, correct?
I'm sorry, could you clarify? I'm not sure I understand.
And this tense feeling of hatred and dislike was present throughout your 4 years on the mock trial team, correct?
It went and came over my time on the team, but some years it was worse than others.
And Mr. Brackman would irritate you by always criticizing your lack of work ethic and your underprepared nature?
Yeah, it really got on my nerves. I was pouring my heart and soul into mock trial, and it's not my fault he couldn't see that.
And this would create a sense of mutual frustration, perhaps?
Yeah, and that's what led to that tension.
It would upset you?
Yeah, it would.
So much so that verbal arguments between the two of you would commonly break out?
Yeah, they would.
At one point, Mr. Brackman even demoted you from the prestigious A team to the B team, correct?
Yeah.
And in your opinion, the B team was full of losers?
Well, there's a reason they're not on the A team.
And naturally, this demotion did not repair your opinion of Mr. Brackman, did it?
No, it really didn't.
It did not facilitate friendship, correct?
Definitely not.
But despite this, you were allowed back on the A team?
I was, sorry. I'll always be extremely grateful to Taylor.
And it is your assumption that this occurred because the A team would never win without your talent?
No, it's because Taylor gave up her spot for me.
But without the two of you, Mr. Brackman had no choice but to let you back on the team.
Well, there was no one else to fill the role.
And as you guessed, you went on to win the reward?
Yeah, I did.
Brackman never did congratulate you, did he?
No, he was understandably still upset with me.
He actually proceeded to condemn your actions.
Yeah.
Criticize you for straying off script?
Yeah, he did.
And this could damage your pride?
It wasn't exactly my pride. It was the frustration of him not understanding the way that I worked. I wouldn't say it was pride.
But it did make you really angry.
Yeah, I got pretty upset.
Furthermore, your accumulated rage resulted in you storming out of practice with a Sharpie in your hand.
Yeah, it did.
You vandalized Mr. Brackman's car, correct?
Yeah, I did.
And although Mr. Brackman never did press charges, vandalism is a criminal offense, correct?
Yeah, I am extremely surprised and lucky that he didn't press charges. I certainly deserved it.
You wrote Worst Attorney Award on his Porsche, correct?
Yes, I did.
You did this act in retaliation?
Yeah, I did.
Revenge?
Yeah, I let my emotions get the better of me.
In your hate for Mr. Brackman, you attacked his car?
Your Honor, I believe this is objection asked and answered. I think we've labored on this point enough.
Your Honor,
Ms. Story, I'm sorry, go ahead.
Your Honor, I can move on.
Okay, go ahead.
You never did like Mr. Brackman, did you?
No, well, I wouldn't say I didn't like him. I really looked up to him. He was an amazing coach. And again, he's on our team so well.
But Mr. Brackman never did like you, did he?
I don't know.
Thank you, Your Honor. No further questions.
Is there any redirect for this witness?
Yes, Your Honor, but first, can I ask for a brief time check?
I see 35 seconds from one of the timekeepers. 40 seconds. Okay, so there you go.
Avery, do you feel remorseful for the vandalism?
Of course I do. I feel awful.
And did you plan on making it up to Coach Brackman?
Yeah, I did. I had so many plans of how I was going to try to make it up to him, but he never listened.
Nothing further, Your Honor.
Is there any recross?
A brief one, Your Honor. Ms. Becker, in your anger at Mr. Brackman, you vandalized his expensive sports car, correct?
I did.
Objection, Your Honor, once again, asked and answered.
Response, Your Honor.
Go ahead.
In co-counsel's redirect, he brought up the point of the vandalism, and I am just emphasizing that point, and I have not asked a single question so far in recross, so I do not believe it has been asked.
I think it's a fair question. You can ask that.
Ms. Becker, in your anger at Mr. Brackman, you vandalized his expensive Porsche car, sports car, correct?
Yeah, I did.
Thank you, Your Honor. No further questions.
All right, let me just confirm all of your names. For the defense, we've got Spencer Wilcox as attorney and Bella Burgess as witness,
yes,
and Cayman Story for the prosecution.
Yes, Your Honor.
All right. Thank you all. I believe that's all of the witnesses for the defense.
Yes, Your Honor. The defense rests.
All right. Is the prosecution prepared to give a closing argument?
Yes, we are, Your Honor.
Okay, you can start when you're ready.
Pride, revenge, and retaliation. That is what occurred on March 6, 2020. A home is a haven, a safe house away from all the struggles and fears of the outside world. However, for Mackenzie Brackman, this was not the case. He was severed from his sanctuary, his refuge breached, a violent act that concluded with the brutal murder of an innocent man. Desperate to defend himself, to live another day, Mr. Brackman courageously faced the alarming masked intruder, only to have his life ripped from his body, his own chef's knife, wielded by his menacing attacker, painfully plunged into his shoulder blade, pierced and slashed his skin, blood spilling onto the floor even after Mr. Brackman's life had faded away. Your Honor, opposing counsel, members of the jury, the defense claims that Mackenzie Brackman's death was an act of revenge executed by the son of an ex-client. However, in their attempt to profile someone as a criminal, they have disregarded many of the case's facts. One of their witnesses, Blake Van Owen, who has a bias against the police officers testifying in this case, presented a theory of the case that was loosely sewn together by presumptions made without visiting the crime scene. Furthermore, Taylor Perkins, the defendant's best friend, testified to the hateful relationship between Becker and Mr. Brackman. Even Avery Becker, the defendant themselves, could not dispute the fact that years of hostile arguments had gotten under their skin. Mr. Brackman's words were an attack on Becker's amassing pride, their hastily earned glory. The undisputed truth is that Avery Becker, out of resentment, anger, and vengeance, vandalized Mackenzie Brackman's vintage Porsche. But did that quench Becker's thirst for revenge? Yes, it is true that my co-counsel and I have the burden of proof in today's case, a burden we have fulfilled beyond a reasonable doubt. Alex Cifuentes, who, like Taylor Perkins, was a close friend of Avery Becker, personally witnessed Becker's malicious desire go too far when the defendant proclaimed their intention to vandalize Mr. Brackman's home in a string of text messages. Did they go through with their threat? Well, on March 6, 2020, Detective Jordan Markowitz discovered Mackenzie Brackman drenched in his own blood, dead. Upon further examination of the house by Detective Markowitz, an expert in today's case, and an in-depth analysis of the evidence by an expert in crime scene reconstruction, Kyle Kuzak, a decisive pattern of events emerged. A masked intruder with the same body and build as Avery Becker illegally entered the residence, and a struggle ensued that resulted in Mackenzie Brackman's death. Furthermore, phone records even placed Becker at the scene of the crime when the murder took place. Members of the jury, you have the heartbreaking and heavy duty of determining blame and enacting justice. So according to jury instruction number 7, when, after considering all of the evidence presented to you in today's case, you determine that Avery Becker entered Mackenzie Brackman's residence unlawfully with the intention to vandalize the property, and in the course of doing so caused the wrongful death of the victim, you must find Avery Becker guilty of murder in the first degree and of second-degree burglary. Yes, it is true that my co-counsel and I represent the people of the state of Colorado, but you, members of the jury, you are the people of the state of Colorado. You alone have been given the immense responsibility, the civil duty of bringing justice to the Brackman family, to their friends, colleagues, and to Mackenzie Brackman himself. This was not an accident. It was a planned burglary gone wrong. It was the action of revenge and rage that ensued when a dangerously proud individual was knocked off their pedestal and resorted to violence. Members of the jury, my co-counsel and I ask you for justice. We ask you to return a verdict of guilty. Thank you.
Thank you, Ms. Story. Would the defense like to give a closing argument?
Yes, Your Honor.
All right, you can start when you're ready.
Can you see me and hear me all right?
Yes.
A rushed investigation and a rush to judgment. What happened to Coach Mackenzie Brackman It's a tragedy. But it was not Avery Becker who committed this crime because she had an alibi, because there was no physical evidence connecting her to the scene of the crime, and because the police failed to investigate alternative suspects. Now, in today's trial, the burden of proof rested with the prosecution. They had to prove to you beyond a reasonable doubt that Avery Becker was the one that broke into Mackenzie Brackman's house, either to break something or to take something, and while committing that felony, caused the death of Mackenzie Brackman. Members of the jury, they have failed to meet this burden because of the rushed investigation and the rush to judgment. Now, what is reasonable doubt? It is the highest burden in our criminal justice system. It is not enough to think that Avery possibly did it, or that she probably did it. You must be convinced beyond a reasonable doubt. And ladies and gentlemen, there's plenty of reasonable doubt in this case. First, Avery's alibi. You heard from both Avery herself and from Taylor Perkins that they were at the mall the entire day in question looking for her phone. Now, the prosecution wants you to believe that call detail records show that she was right at Mackenzie Brackman's house. But you heard from Professor Van Owen that this simply isn't true. Even Detective Markowitz herself said, quote, "It is possible that the phone wasn't where they thought it was." Of course, the police could have looked farther into this, but in their rushed investigation and their rush to judgment, they thought that it wasn't necessary. The lack of physical evidence. As you heard from both Detective Van Owen and the prosecution's own witness, Detective Markowitz, there was no physical evidence connecting Avery to the scene. There is no DNA, no fingerprints, no hair fibers, no clothing fibers, no footprints, nothing except a Ring video camera. And as Kyle Cusack said, all this shows is a general height and a general build that could match anyone. The alternative suspect. You also heard from Blake Van Owen about Blair Rollins, an alternate suspect in today's case. You heard Exhibit 22, the court recording of Blair Rollins' father saying, "I'll get you back, Brackman, if it's the last thing I do." Blair Rollins was in the courtroom that day, hearing his father threaten the victim. And as you heard from Professor Van Owen, he wasn't at school. He had the motive, he had the means, and now he has fled the state. The police didn't even investigate him, instead deciding to go off the first lead they got from none other than Alex Cifuentes, a person who had something to gain from Avery not being on the mock trial team. Now, the prosecution would like you to believe this is some elaborate revenge and retaliation, as they call it. But the only person who wanted revenge in this case was Blair Rollins. Now, as a defense, we didn't have to prove anything. That burden rested with the prosecution. But members of the jury, their case was full of questions. What about the alibi? What about the lack of any physical evidence connecting Avery to the scene? And what about Blair Rollins? The answer, reasonable doubt. And it is for that reason that we ask you to return a verdict of not guilty. Thank you.
Thank you, Mr. Wilcox. Do the people wish to give any rebuttal?
Yes, Your Honor. May I ask how much time I have remaining for rebuttal?
It should pop up in chat in just a second.
Thank you. The defense may claim that Detective Markowitz and Kyle Kuzak conducted a rushed investigation. This is simply not the case. Both experts testified to the tedious investigations they conducted. However, the defense's one expert, who testifies for fun, never visited the crime scene and conducted no individual investigation of their own. He's only criticizing the facts. That, members of the jury, that is a rush to judgment. Once again, the people of the state of Colorado ask.
We're out of time.
Okay, thank you.
All right. Well, thank you all. This really concludes both this round and the competition. If either of